and it was rescheduled.
Yes, I believe that's correct.
And counsel,
Yes.
as to the pretrial.
Yes, with respect to pretrial, we would like to get a look at the discovery materials as the court for a short adjournment and the entry of that discovery order for that purpose.
The court will sign the discovery order. And counsel, you're back on December 19th at 10 a.m.
Yes.
All right, so December 19th at 10 a.m.
Thank
And ma'am, if you were to test today, what's in your system?
Weed. I haven't been doing anything else. I have smoked weed.
Do you have a prescription for marijuana?
No, ma'am.
Okay, well, do you recall this court's order on your, at your arraignment not to use or possess any alcohol or drugs that are not prescribed?
If I get a prescription, am I allowed or?
That wasn't my question.
No, I do apologize.
My question was, do you recall this court's order that you're not to possess or consume any alcohol or drugs without a prescription? You do. Yeah, you're using marijuana while on bond.
I haven't been using it all the time, but yes, I have.
Okay, and then when I asked you what you would test positive for, you,
I said,
you did. Like it was no.
Sure, I'm Neil Boyd, P3687 here on behalf of Angela DiMaggio.
All right, and ma'am, your name, please. Okay, and change the date scheduled for the arraignment pretrial of this matter, and counsel asked for the arraignment.
Yes, with respect to the arraignment, we're going over the charges. We understand, and she's saying mute to those charges, and we would waive formal reading.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and ask the pretrial counsel.
Pretrial, Your Honor.
Lawyers often try to keep co-defendant cases together. It's a strategic move to ensure that if one person gets a favorable plea deal or discovery evidence, the other can potentially leverage that same benefit.
You know that there is a companion
I'm
case
so
that
sorry.
we've already addressed.
I'm so sorry. There's also,
Yes.
there's a lot of other cases for Ms. DiMaggio, but let's just finish this one first, that's fine.
With respect to, all right, with respect to, you know that there is a companion case, a co-defendant that is assigned to Attorney Shipke, and to keep these cases together with separate counsel, which is where I'm at on this matter. We are seeking a similar adjournment as the companion case for purposes of companion discovery.
All right, the court will adjourn this pretrial to January 2nd at, is that maybe the other one? Mr. Hill, I believe. Hill. Was it Mr. Hill? Yes. What time did I do that on the 2nd of January?
At 9:30.
9:30, okay. All right. I'm sorry, 184241 and 184242. And the court will schedule all these matters for pretrial on January 2nd at 9:30 in the morning, and counsel as to bond on these matters.
With respect to bond, Your Honor, I can only say that my client has expressed a keen interest in getting all of these matters resolved once and for all.
Well, ma'am, what's taking you so long to come into court on these matters?
I was in jail and I was on tether for 2 years and I was unable to get the, I put in FOIA and the information's unavailable. She said she doesn't have any of the, actually my FOIA, sorry, paperwork is right here. She has no records seeking prior to May 5th, 2021, and no access to records. Wait, let me see, prior to August 2nd, 2007, and after May 5th, 2021. So I was unable to fight the charges and get the information for it. There's no tickets and there's no records of it at all. Yeah.
November 17th. And this is from the records department for the Wyandotte Police Department, not from the court clerk. indicates any records you are seeking prior to May 5th, 2021 may not be available or partially available at this time. We are currently experiencing issues with that system and have limited access to it. At this time, we are only able to access records prior to August 2nd, 2007, and after May 5th, 2021. Sorry for the inconvenience. That's either November 17th of 2023. Okay, great,
Right.
great. That doesn't tell me why, for the last 5 years, you've not appeared in court on your 2018 matters, or
Because
why,
I
for the
was-
last 3 years, you didn't appear on your 2020 matter. So why haven't you appeared at all?
I don't know. I don't know. I had a tether on for 2 years, and I thought that if I had a warrant out for my arrest, that they would have picked me up on that.
Ma'am, what matter did you have a warrant out for your arrest on?
Apparently for you guys.
I'm sorry. What matter were you on tether for?
Something with Lincoln Park for 2 years. I was fighting a case.
So what years was that?
2018 till,
In the legal world, being scared is the most common excuse for a failure to appear warrant. While humanly relatable, it carries zero legal weight and often makes the judge think the defendant is a flight risk who needs a higher bond.
Because I need to assess bond. I need to ascertain whether or not you're going to be showing back up for court, and you don't have a history of showing up for court. So I'm trying to figure out why you haven't appeared in court.
well, I guess I was scared.
Are you currently on probation or parole anywhere?
No.
And so what happened, so you indicated that you were on tether on a case out of Lincoln Park.
Right.
Is that for the matter in e-course? They're all at the same court, that's why I'm asking.
It was for River Rouge.
River Rouge, the matter from 2014? No, that's a traffic offense. 2020,
I have a problem with a specific officer that did some really, talk about it, okay?
Ma'am, I'm not showing anything from River Rouge on your record, I'm showing 2 matters from e-course.
See what I'm saying?
Well, I'm sorry, let me clarify. There's a matter from River Rouge, but it just shows there was a notice to appear. I don't show what happened as a result of your court date. But I'm showing 2 matters from e-course.
I paid $1,100 in fines. Okay, in Lincoln Park. And I did 90 days in jail, and I was on a tether for 2 years. And I guess I was just scared here, okay? I want to take care of this stuff, okay?
Okay, ma'am, if you're tested right now, what's in your system?
Nothing,
Nothing.
nothing but my doctor, that's it.
Along,
My son's at home with my mother-in-law or his grandma that is sick today. I take care of her, home health care.
okay. Well, I also saw you and Ms. Thomas chatting and then both leaving the courtroom. And so I want to make sure that you are substance free right now. Are you substance free right now?
I have nothing to do with her.
Ma'am, I'm going to have you go over to probation and you're going to test right now. Is there going to be anything that's showing up in your system? I'm going to take that as yes. So what is going to show?
No, I refuse.
You refuse
That's
what?
against my constitutional rights. I am not gonna, no,
You're not going to what, ma'am?
I'm not gonna hold myself. I'm not gonna. Exercising my constitutional right. I don't have to do that.
You don't have to what?
I don't have to go. You want to throw me in jail, throw me in jail.
If the court orders a condition of bond, ma'am, that you're to test,
Then throw me in jail.
then that's a condition of your
Then
bond.
throw me in jail. Okay, I'm gonna come back and take care of this. It's a stupid driving on a suspension, okay?
Well, and you have your current drug, possession of drug paraphernalia, And then you have a second driving license suspended. How'd you get here today?
I got a ride,
From whom?
my son's father. The vote gave me a ride.
How are you getting back home? $5,000, 10% bond. In the event you post bond, man, you're not to possess and consume any alcohol or drugs unless prescribed. You'll be subjected to random testing. So in the event you post bond, you are to make sure that you are contacting the court here, the probation department, within 24 hours of your release to get set up with your random testing. All right, and we'll see you back on January 2nd. The court's gonna also order as a condition of bond GPS tether, no house arrest in Wayne County Jail. All right, thank you. We're gonna be going with the officers. Thank you.
Awesome.
All right,
The moment of truth arrives. When a defendant is recalled after a short break, it usually means the lab results are back. Notice how the defendant's body language shifts from defensive to pleading almost instantly.
We're going to go off record for a quick moment, then we're going to redo Ms. Thomas. We're going to recall Ms. Thomas. And then judges arrested for a quick moment. Okay, we are recalling the matter of Samantha Thomas, 231336 A and B. So, ma'am, you tested over probation because I had some concerns that you were under the influence of something.
I am prescribed Suboxone and Courtroom. And I do have the pill bottles, I'll bring them up for you and all that.
Okay, but did you not just indicate to the court that only marijuana would be in your system?
I wasn't really thinking, because it's been like in the moment, and I'm like frazzled in my
Who's
head.
your grandmother?
She's not in here, I have to, go outside.
Yeah, you need to speak up.
I have to go outside for her.
She's outside.
She should be, yes.
Okay, and what kind of car did she drive you here today in?
Gray Escape. Or, it's like a brand new one.
You did drive here.
No, I didn't drive.
Do you have a copy of this discovery order?
Yes, Your Honor.
Ma'am,
Yes, ma'am.
where do you work?
I work at 7-Eleven. I can assure you that next time I come back in court, I won't have weed in my system or anything.
Well, ma'am, I'm just wondering why I shouldn't revoke your bond right now, because you were ordered back in August not to possess and consume any alcohol or drugs that are not prescribed. And you have marijuana and cocaine.
I really don't know how the cocaine got in there. I swear. And I know you probably heard that like 100,000 times. But
Not quite, maybe only about 98,000.
right. But I can swear to you next time I come in the court that it'll be clear only what I'm prescribed. I mean, I don't know if you were able to test like levels or whatever, you'd be able to tell it that way. I mean, from today on, I won't.
Ma'am, I have concerns that you're under the influence of something right now. Either you're taking, well, other than the cocaine and the marijuana, right? Which marijuana you used when, yesterday?
No, it's gonna make me lose my job, and where's that gonna put me? You know what I'm saying? If my
Ma'am, do not, listen,
No.
do not come in here trying to
No, I'm
make
not.
it appear as though I am going to be the reason you lose your job.
No, I'm not.
Your behavior and actions would be why you lose your job.
And I am assuring you that I will not be like that. I will not fail the drug tests. And I mean, that's all I can do. I really don't want to lose this job. I like this job. I like the people, you know, and it's convenient for me. It's right down the street from my house, and I help take care of my grandma.
The realization finally hits. Bond is a contract with the court. When you break that contract by using prohibited substances, the grace period ends, and the court reverts to the safest option: physical custody.
I mean, I'm not gonna give you my whole sob story, because you hear it all the time, but that's all I can do is, you know, just try to do my work.
Well, counsel, here's what I'm going to do. I'm going to revoke your client's bond. I'm going to move up the pretrial, so that it won't be until December 19th. Can you be here on either the 5th or the 12th? I know that you're not scheduled. Okay, we can do 8:30. Well, first off, ma'am, those are not my officers.
I know, I'm just upset right now,
Well, it's fine, Your Honor, I could be here on the 12th.
so I'm going back to jail.
Yes, ma'am.
You're gonna put me back there. There is nothing I can do.
Ma'am, you tested positive for cocaine. You've used marijuana in violation of this court's bond.
You had, during the matter, you were considering sending her for testing. We did in the interim, directed your court personnel to provide us with a look at the test stick that, my client had used, for lack of a better word. Again, I am not an expert on such things, neither is court personnel. There is an indication that brought up the issue of whether fentanyl was present. There's a mark. There's supposed to be a mark indicating, sort of intuitively it's backwards. There's a mark
Correct.
that indicates that a mark is good. There's
Correct.
a slight mark at fentanyl.
Very, very,
Is that
very
slight good?
faint.
Is that slight, but it's a
No,
mark yet.
No, I understand.
She insists she has not had cocaine nor fentanyl in the recent past. And I don't know what the levels are, how long this will protect, or what the percentage reliability of such tests are. I didn't witness the test being done. My position is the test is invalid. She's willing to do more intensive testing. She's offered to do that. What is the?
I said I would go to
Concentra?
Concentra, be back here at 8 AM in the morning to show you proof that I have not.
So I think there's doubt here. We'd ask the court to give the benefit of the doubt.
So here's what I'm going to do, counsel, because she's looking at jail time and you're going to go test today, and then we're going to get your levels as
Well,
well.
that's what I meant. Okay, I'll just wait for probation, sorry.
8:30 AM. Counsel, you can be here on the 5th at 8:30 AM.
So the 12th will be off, correct?
Yes, nothing on the 12th. We're back to the 19th for the pretrial at this point.
All right.
And then at 8:30, and then the December 5th for the bond violation hearing, which is 1 week from today at 8:30. Does the 5th work for you, counsel?
Oh, I'm sorry. Yes.
Okay, I just wanted to make sure. Okay. All right. Ma'am, do not leave without going to probation, and they will tell you where to test, and when to test. I believe the testing center reopens at 4 o'clock.
Okay. Thank you very much.
Have a good day.
Thank you.
Okay. All right, we are on the record in the matter of Heidi Hoffman, 231540.
Your Honor, we're on the record actually on two matters. That appears to be a formal hearing.
For Ms. Hoffman?
The number you just called.
No, it's up for a hearing because it was a bond violation hearing. She pled not guilty. And so she entered into a plea on October 31st.
The video ends with a bench warrant for a different defendant. In court, punctuality is everything. If the judge reaches the end of the docket and you aren't in that seat, the warrant is printed automatically.
And then we set it to today's date and for her to test on November 24th.
That's correct, Your Honor. And the whole scenario. She called me that morning, actually, that morning, saying, back last week. That's why she was on Zoom.
I understand,
We
yes,
went all through that. I agree, Your Honor.
yes.
But I think the case number, if you look on the docket, I know we have this matter scheduled for today, but the case number that you read,
Right, it says hearing,
hearing,
yes.
but
It's not a formal hearing. It just doesn't have all of her other cases on it, on the docket.
okay, Your
It
Honor.
says hearing, but it only showed for the no proof for insurance. It should have also showed for the other two matters, but it didn't. So it's just showing hearing. Otherwise, it would have probably shown as formal hearing. But I don't know, in any event,
Okay, I just want to
there's
make
not a
sure,
formal hearing, it's a bond violation.
I
hearing.
understand that.
Yeah,
Okay, because can I get my file? I just did bring it. So, yes, you're right, that is the case number, and I do understand.
and so
For 130.
it sure was scheduled for 1:30. The court will also note that Ms. Hoffman was ordered to test on October 31st, but did not even show up to test until November 2nd. So that's also the
That was
violation.
back before, yes, that was also,
Yes, so, and obviously in the other violation, that's a positive for methamphetamine.
that's correct.
And amphetamine, I don't recall if she had a prescription for that. But in any event, she's not here, she's ordered to be here, it's 3:40, and therefore a warrant's going to issue.
Your Honor, I just want to make the court clear, I did notify her of these proceedings when we last left the court. Also, Your Honor, I also called her today, left a message on her answering machine, and I also texted her that she was being in court at home. I have not heard a response from her. So I have no reason as to why she.
All right, the court's going to note that based upon Ms. Hoffman's previous failure to appear and leaving on her own without any communication with any court staff or approval, the court's going to order $10,000, 10% bond warrant issue immediately.
Thank you, Your Honor.